Hello and welcome to this summary of our 12th annual employment law breakfast briefing. So this is a recorded webinar summary of an event we ran in January of 2024. And essentially I'm going to try and give you a whistle-stop tour of some of the changes that are coming in for employment law in 2024 that employers need to be aware of. For those of you who don't know me, my name is Ian Machray and I am an employment partner here at Field Seymour Parks. So we've got a fair bit to get through in this session today. Without further ado, let's talk about what we're going to be looking at today. So what we're going to start with is what's in store for this year. We're going to look at some changes to retained EU law, then some implications for holiday pay, particularly around irregular hour and part-year workers, changes to working time regulation record keeping, and some alterations to the TUPE regulations. Got a new duty to prevent sexual harassment coming in later this year. Changes to flexible working, a new right to request more predictable working, changes to redundancy protection, a new carer leave, some changes to paternity leave, and then some changes to tips and to national minimum wage. Then I'll have a brief look at the general election and what that might mean for employers and employment law. And then there's a few other areas to watch, which I will pick up and mention in brief at the end. Now, every year when we do this session in person, we do a poll to ask people what their number one HR priority is for the year. We only give them a choice of 4 categories. But what you can hopefully see on the screen there is the answers from 2020 through to the most recent session earlier this month. Always useful and interesting to see sort of a trend of where priorities can lie. Obviously, big changes since 2020. Obviously, COVID affected year, changing working practices, number one priority for lots of businesses. You'll see how that has fallen off since then, and the rise up of recruitment and retention, which was the number one priority in 22 and 23. This year, recruitment and retention is still that number one priority, but it has eased off, and you can see that restructuring and cost cutting has become a higher priority for a lot of businesses as well, and that's actually higher now than it was back in 2020 in that sort of COVID affected year. So anyway, that's interesting summary of what people's priorities are. Let's have a look at what is in store for us in terms of employment law. So first thing to talk about is the Retained EU Law Act. So I've given you a little quick reminder there of where we currently are. So Brexit occurred on the 31st of January 2020. We then had our transition period ending at the end of that year. And at that point, in very simple terms, all retained EU law basically moved on to sort of the domestic law basis. Now, in the session last year, I talked about the Retained EU Law Bill as was proposed at that time. And in essence, the way that bill would have worked in its original form is it would have revoked all EU legislation as of the 31st of December 2023, unless it was expressly preserved. Quite a hostile reaction to that. A lot to do with the logistics of managing the number of laws that there are and making proactive decisions about what is to be retained and not. And that bill was then amended before it was passed with that sort of sunset clause, with that automatic deletion of EU law coming out of the Act. So why is it still important? Well, it still makes some changes to how EU law, or what used to be the basis of EU law, is dealt with in the UK. So we've got new powers for the government to reform EU-based laws. EU law is no longer supreme over domestic legislation, and there's also no longer this need for consistent interpretation. So some of you who have followed case law in the past will sometimes see the domestic courts having to try and read words in or interpret domestic legislation so it fits with EU legislation. With EU law no longer being supreme, that falls away as a concept as well. Some directly effective EU rights also fall away as well, although there have been regulations passed by the government to replicate some of those, particularly relating to discrimination and equal pay. And then there's this sort of encouragement to sort of challenge, I guess, European court decisions. So this sort of indication that decisions of a foreign court are not usually binding, which is encouraging the Court of Appeal and the Supreme Court to overturn decisions. And also there's going to be a new reference procedure allowing sort of lower courts and tribunals to refer points of general importance up to those higher courts that can ultimately change the law. And we've got this new terminology. So retained EU law is now going to be called assimilated laws. So what does this all mean? Well, there's some immediate changes that are linked to this, which I'm going to come on to in my sort of next few slides. It is likely to increase uncertainty. So some of the sort of relatively settled principles that have been built on European court decisions, in particular around maybe what counts as working time, how to count redundancies in a collective redundancy scenario. Those sorts of things might be more open to challenge. The government has committed to sort of preserving employment rights and saying that they will make changes incrementally after consultation. And there are some limitations with the trade agreement we have with the EU, where we essentially guaranteed that we won't weaken or reduce our labour laws as they were at the time that was signed off. The big question mark is obviously we have a general election. So where this goes from here may well depend upon who is in power. But let's have a look at some immediate changes that are linked to this. And the first way is relating to holiday pay. I think I talk about this every year, I think, really. But these changes are linked to a case I talked about last year, which is this Harper Trust case. And you may remember this dealt with, in particular, how to calculate holiday for irregular workers. So people who don't work set hours throughout a year. And that case essentially said that you couldn't calculate holiday on a percentage basis. You had to use what has been called the calendar week method, so looking back at a reference period. And it also said that when you look at that reference period, you have to ignore weeks that have not been worked at all. And in essence, that case caused some logistical issues for employers in terms of managing holiday. And it also meant that those irregular hours were essentially getting disproportionately more holiday pay than regular workers. Government had a consultation about essentially that case and changing the rules, and it has resulted in this new set of regulations, introducing changes in particular for irregular and part-year workers' holiday pay. And it's in essence a new regime. So the key thing to start with this is, well, what's an irregular hour worker and what is a part-year worker? So an irregular hour worker is assessed by leave year. And the question is, are the paid hours in each pay period of that year under their contract wholly or mostly variable? So by way of example, if someone is a 0 hours casual worker, it will be the case that their hours are certainly wholly or mostly variable under their contract. What it probably wouldn't cover is someone who works a fixed shift pattern. So let's say week A, they work a certain number of hours on certain days, and then week B, they work a slightly different setting, and then it carries on repeating. Now, because essentially those hours are fixed under the contract, they may change between those 2 weeks, depending if it's week A or week B. Because they're fixed, they're unlikely to be an irregular hour worker. Part-year worker, again, assessed by leave year. Are they required to only work part of that year? And are there periods in that year of at least a week that they're not required to work and they're not paid? So if you have a seasonal worker, maybe in agricultural business, only working in the summer months, and then they have other periods of the year where they're not required to work and they are not paid, they may fall within this category. An employee that might be someone who's on annualized hours, because they will have periods where they are not working, but if they are paid for them, they wouldn't fall within this definition. So that's our irregular and part-year workers. What's changing? Well, for leave years starting on or after the 1st of April, so you've got to think about when your leave year starts. So if you're on a calendar year for your leave year, these changes may not be effective until the 1st of January 2025. So it could still be a little way off, depends on when your leave year starts. You've got this new approach to holiday pay. So it is calculated in hours, not weeks. It accrues on the last day of each pay period. It is calculated on a percentage basis, 12.07%, which is essentially 5.6 weeks expressed as a percentage of the number of working weeks in a year. There's then a 52-week reference period if someone is on sick or statutory leave for the purposes of calculating their holiday entitlement. It is a single entitlement, so there is no distinction between the original 4 weeks that came from EU law and the further 1.6 weeks that comes from domestic law. And you can round up and down. So if it is 30 minutes or more, then you round up to the nearest hour. If it is less than 30, you round down. And then in simple terms, you then have two options as an employer. You can do similar to what you're doing currently. So you are making payments of holiday pay when holiday is actually taken. So someone says, I want to take some holiday, you agree, and then you calculate their holiday pay whilst they are off. The alternative is rolled up holiday pay. So this was previously unlawful, but this is the idea that you pay an additional sum of money by way of holiday pay each pay period, and the employee then has that money that they can use to draw down and use when they take holiday. So there's not a link between the absence from work and the holiday pay. They're not paid at the same time. Now, if you are doing rolled up holiday in these circumstances, it needs to be paid at the same time as the work is done. So if you're paying monthly, you need to be making your holiday pay, rolled up holiday pay payments monthly. It needs to be itemized on the pay slip, and you still an onus on you to make sure they're taking 5.6 weeks leave a year. So you just can't completely wash your hands of ensuring that they are taking a holiday. The other thing that is important with these regulations, we have a new definition of weeks pay, and this applies to all of that statutory holiday for irregular and part-year workers, and the first 4 weeks of holiday for regular workers, so not the further 1.6 weeks that comes from domestic law. So you still, for regular workers, have a slight distinction between the holiday that comes on an EU basis originally and the 1.6 further weeks that comes from a domestic basis. The reason that's important is what constitutes weeks pay for those different types of holidays is slightly different, and the rules relating to carryover of that holiday are slightly different as well. The government hasn't fully simplified the holiday pay system in the way many people would have liked. But anyway, this new definition of a week's pay is designed to replicate a number of the European decisions that you will have been reading about over a number of years now in terms of what should be included when calculating someone's holiday pay. I've put on the slide a rough summary of what those 3 things are, but it's payments including commission that are intrinsically linked to the performance of tasks obliged to do under the contract, payments for professional personal status relating to length of service, seniority or professional qualifications, and then other payments such as overtime, which have been regularly paid in the preceding 52 weeks. So it's designed to replicate those sort of EU cases. It doesn't do it completely because ultimately they're based on a number of different cases with different scenarios. And there's still some areas of uncertainty. So for example, that first bullet point there, payments including commission, does that, for example, include annual bonuses? Generally speaking, to date, that's been assumed that they are out of scope, but will that be the case going forward? We have to wait and see. Other things to note then with holiday, the carryover of holiday, the regime is broadly the same as it was previously. There is a slight distinction between sick leave carryover, which is that there's a distinction between regular and irregular or part-year workers now. So your regular workers can only carry forward 20, your irregular or part-year workers could carry forward 28. And that's because of this slightly unusual distinction between 4 weeks and the further 1.6 weeks that is maintained for regular workers, but not for irregular and part-year workers. And then the regulations that allowed for carryover of holiday because people were unable to take that due to COVID, they are removed from the 1st of January, although if people are carrying over, they have until the end of March 2024 to make sure they take it. Okay, so that's holiday pay. More changes that are linked with this change to EU retained law. We have some clarification relating to working time regulation record keeping. So Regulation 9 of the Working Time Regulations basically says employers have to have adequate records to show compliance with the 48-hour maximum working week and the night working restrictions. Now, this was called into question a little bit by this ECJ decision involving Deutsche Bank. And what appeared to be suggested in that case is that employers needed to have a specific system to monitor actual daily working time, not only for the 48 working week and night working, but also for daily or weekly rest periods or rest breaks. So essentially increasing or suggesting that there is a higher threshold for that record keeping. Governments passed these regulations that clarifies that record keeping requirement. So firstly, it makes it clear that there is an element of employer discretion as to that system. So those records can be created, maintained and kept in such manner and format as the employer reasonably thinks fit. And there's not a need to record each worker's daily working hours, provided you can demonstrate compliance without doing so. So essentially trying to say, as you were, and the Deutsche Bank case doesn't impact upon current record keeping requirements in the UK. So before we move on to some of the TUPE changes, what are your action points related to these things? Well, the most important thing is that you are identifying if you have irregular or part-year workers under the regulations in your organisation. And you need to be very careful with those definitions, because if you get it wrong, you could end up having an unlawful holiday pay regime. And the most obvious example is you can have, provided you do it in the right way, rolled up holiday pay for your irregular workers. You still cannot for your regular workers. That is still unlawful. So if you get it wrong in terms of classifying your workers, which sort of holiday pay regime they fall into, you could end up with an unlawful holiday pay system. Check your implementation date. As I say, that is linked to your holiday year. Then think about your preferred holiday option. Are you still, for your irregular and part-year workers, going to pay them holiday when they take it, or are you going to operate a rolled-up holiday pay regime? You then need to check your contractual obligations. So what I've been talking about here is statutory holiday, the holiday you have to give. You might enhance your holiday pay above that. And also you need to check if you are making changes to how you operate holiday that you don't inadvertently end up in breach of your employees or workers' contracts. So you need to check your contractual obligations, and if you have an issue, you're going to have to make sure you resolve that in good time before the changes take place. Check the week's pay requirements. That's for all staff really. You need to make sure you're calculating that in the right way and including the different allowances, overtime, commission, etc. that might be required, and make sure you've got appropriate working time records in place. Right, something a little bit different. I'm going to move on here. We've got some changes to the TUPE regulations. So hopefully most of you listening to this will have some idea of what they involve, but essentially they're enhanced protections for employees where there's transfer of a business or part of a business, or there is a service provision change. It's a little bit more technical than that, but ultimately they most commonly come up where there is a sale of a business or part of a business, there is outsourcing of services, insourcing of services, or there is a change in the service provider of a service that has been previously outsourced. Those are the most common scenarios. Anyway, if you have a TUPE transfer, there is an obligation to inform and sometimes consult about it before it takes place. And currently, unless you are a micro business, that has to be carried out via formal employee representatives. So micro business is a business that employs fewer than 10 people. So if you don't fall into that category, you either need to consult with a trade union if you recognise them, or you may need elected employee representatives. And these new regulations essentially change and remove the requirement for those representatives. And you won't have to inform and consult via representatives. You can go direct to the employees where there are fewer than 50 employees in total, or there is a transfer of fewer than 10 employees. And when you're counting that, you've got to look at those who are or are likely to be transferred. It will only apply when there's no existing reps in place. So if you already, for example, recognise a trade union, you can't use these regulations to say, oh, we're not talking to you, we're going to talk to the employees directly. Quite a useful change for many employers, the obligation to do everything through representatives, particularly for small scale transfers, can be onerous because you could have a transfer of, say, 3 employees, and technically you should have reps for it. Often employers don't honour that anyway. This doesn't come in, only applies to transfers on or after the 1st of July 2024. Before that date, the existing rules remain in place. Right, change into something a little bit different now. Sexual harassment. This was something I trailed last year in this session, and we have some additional protections essentially coming in, due to come in on the 26th of October 2024 currently. I've put on the slide a bit of a reminder of the existing law relating to sexual harassment, or at least a summary of it. And under the current law, sexual harassment occurs where an individual, on the slide here, engages in unwanted conduct of a sexual nature, and that conduct has the purpose or effect of either violating another person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. I think it's fair to say that the current law, there's sometimes a misunderstanding of how broad it can be. So potentially it can apply, it is purpose or effect. So can catch behavior that wasn't intentional, didn't intend to upset anyone. And also, it doesn't have to necessarily be directed at someone as well. So you can create an offensive environment for someone, even though your comments or your actions are not particularly directed towards an individual. One of the examples is sort of having inappropriate sexualized imagery around the workplace, inappropriate posters on walls, things of that nature. You could create an offensive environment for someone, even though you are not doing anything that is directed at them themselves. Key point to note here is this new act doesn't introduce express liability for the actions of third parties. So this was originally planned in the original version of this bill, and certainly something that I talked about last year, and that was removed as it went through the sort of parliamentary system. Now, you still have to be careful. Ultimately, from simply a good business perspective, you do not want third parties sexually harassing your staff, but equally you could still have liabilities if you don't respond to that in an appropriate way. So whilst it's not an express element of this new act, it is still a risk for employers. So in a way, that's what hasn't changed. What has changed? Well, you've got this new mandatory duty to take reasonable steps to prevent sexual harassment of employees in the course of their employment. It is only sexual harassment. It doesn't apply to the other forms of harassment. And it is reasonable steps, not all reasonable steps, which is another change from the original bill as it was drafted. It's watered down slightly through the parliamentary process. We don't have a huge amount of guidance on what reasonable steps means. We are expecting statutory code of practice, which might provide some guidance. The other area that is useful when considering this is all reasonable steps is a defence that's available under the Equality Act. So there's a number of cases around things that do and don't qualify as that under that existing legislation, which is helpful. Equality and Human Rights Commission can enforce through their sort of investigatory powers breaches of this duty. Important thing to note is that it's not a claim, it's not a standalone claim in itself. So if there's a failure to comply with this duty, you can only bring a claim about it if you have a standalone sort of normal sexual harassment claim. So you can't bring a claim saying you have breached the duty or you failed to take steps when sexual harassment has not occurred. The key thing, there's a 25% uplift on damages if a breach is found. That could be considerable. Claims would be uncapped, and that would apply to not only the element of sexual harassment awards, but also to all awards for harassment that are found. So that could cost a lot of money. Yeah, we are still awaiting this draft of the statutory code of practice. So new obligation as of October as planned. Well, what should you be doing about it? Well, the key thing, obviously I don't know when you're watching this webinar, but the key thing is to take steps in advance of it coming in, because you need to be able to demonstrate by the point it's in force that you've taken your reasonable steps to ensure that it's not compliant. What we would recommend is that you undertake a risk assessment of sexual harassment occurring in your business, because what your reasonable steps might look like will differ depending upon your business as opposed to others. It can't be a one-size-fits-all solution. Once you've done your risk assessment, that should then feed into updated policies that reflect your risks and how you are going to take steps to try and reduce that risk in your business. And then you need to have regular, bespoke and fresh training as well. And the reason I sort of use those words is had recent cases saying that stale or tick box training is unlikely to be sufficient to establish a defence to a claim. Now, I've then put and more because you need to be looking at that risk assessment and working out what else you can do. So you might need to look at your reporting requirements. You might need to look at areas that are particularly high risk. How do you mitigate that? You might want to look at the risks that you have from third parties. You might want to look at how you use settlement agreements. Are they being used appropriately? Do you need signs up so that people understand that you have a zero tolerance? Do you need employee surveys to make sure people are aware of your policies, they feel safe in the workplace? All sorts of things that you can do. Now, one thing I've mentioned on this slide in particular is a new sort of product we've been developing in anticipation of these changes to give people a cost-effective means of assessing their risks and demonstrating that they have taken reasonable steps to ensure sexual harassment doesn't occur. So it's basically built around a risk assessment. It's an online smart questionnaire, asks you questions about your business and your current practices. We then combine that with a review of your existing policies, and then we produce a report and recommendations based on that information with various things that we suggest. There's a fixed fee for that service, and then once that's carried out, you are free to then implement those recommendations yourselves. And if you need further support from us, then obviously we can help with that implementation too. Right, on to something different. Flexible working. So these are some changes to the existing flexible working regime. There's an act, there's some regulations. The key thing is the date is proposed to be the same for both of them, which is the 6th of April 2024. And what they do in combination is it removes the length of service requirement, so no longer a need for 26 weeks to formally request flexible working. When you make your application, when the employee makes their application, they no longer have to explain the effect of their new working pattern or proposed working pattern and how that could be dealt with. Can now be 2 requests in a 12-month period. The employer has to consult before it is refused, and the time limit for that process is reduced down to 2 months unless a longer period is agreed. There is a new draft code of practice. It's published, I think, on the 11th of January. Please do read that. A couple of key points from that code. It does state that employers need to be clear about the information that has to be included in an application. So quite wise for you to have a flexible working policy that makes it clear how an application can be made. There's a requirement for genuine discussion and genuine consultation. So once upon a time, employers would sometimes have a meeting with the employee about their flexible working request, say, tell me what you want, and then they would just go away and give an answer in writing. That's unlikely to be sufficient anymore. There needs to be some active, meaningful consultation before the answer is given. And there's a positive obligation in that code to discuss alternatives if the original proposal doesn't work. So what do you need to do with this? Well, update or have the flexible working policy. If you have any associated forms, then they need to be revised as well. Make sure that your managers have awareness of this, because when a request comes in, they're going to need to do something with it, or at least pass it on to someone to do something with it, and consider training on the process for whoever is handling it so that there is meaningful and genuine consultation. Right, similar but different. We have a proposed new ability to request more predictable working patterns. Now, this is expected to come in force in September. There is a new code of practice out for consultation until the 26th of January. And this is designed to apply to employees, workers, and agency workers. The rules are similar for each group, but there are some differences. I've endeavored over the next few slides to give you a bit of a summary of the process. But yeah, please do look into it in detail, because there is a lot of detail in the Act. But the idea is that there is a right to apply for a change in terms and conditions if there is a lack of predictability in any part of a work pattern. The change that is requested relates to that work pattern, and the purpose is to get a more predictable, you guessed it, work pattern. So most commonly, this will probably be casual workers or 0 hours workers, because of the lack of predictability they inevitably have. But it can be broader than that, because you have to look at what a work pattern has as its meaning, and it can mean the hours, days, or times of work, or the period contracted to work. So if a fixed term of 12 months, if someone has a fixed term of 12 months or less, then there is a presumption that there is a lack of predictability. And if someone requests a longer fixed term or a removal of the fixed term entirely, then that is regarded as seeking a more predictable pattern. So your fixed term, short-term fixed term contracts could be, you might not automatically think there's a lack of predictability there, but you could be getting requests in from those employees as well. If they want to apply, they need to say what they want, they need to say when they want it, and they need to put it in writing. There is an expectation that there'll be a need for 26 weeks service, and there is an expectation that the individual needs to be employed in a prescribed period before they make that application. Now that is to be determined. We're expecting some regulations to link in with this Act that may provide some more detail on this. But the idea is, obviously, some of these individuals will be carrying out duties and then not working for a period of time because of that lack of predictability. So there's a need for them to have been sort of engaged in a certain period before the application is made. So there's a recent relationship. Process, you have to consider the request in a reasonable manner. You've got 1 month to decide it. The reasons for rejecting it are similar to those for flexible working. There are specific rules, which I won't go into in this session, if employment ceases partway through that application. If you are going to grant a request, that needs to be on not less favourable terms and conditions, and somewhat unsurprisingly needs to reflect the change that's being requested. And a couple of points just on agency workers. So they can apply to the agency for more predictable working, but they can also apply directly to the hirer for a worker or employee contract. And that, if it is to be granted, means that it needs to be on not less favourable terms than comparable hirer workers, employees, those directly engaged people. And if there aren't any, then you need to work out the terms that would have been included if you did have such workers and employees. Now, there's going to be some requirements for those applications. Likely you'll have to be in the same role for 12 continuous weeks and enroll at the time of the application, but you do need to be aware that there is the possibility of agency workers applying direct to the hirer. No more than 2 applications in 12 months, which may include flexible working requests if they are also for the purposes of getting more predictable working pattern. Failure to comply, employment tribunal claim, generally need to commence that process within 3 months. And then if there is a breach, the tribunal must make a declaration that there has been, and then it can do either or both of requiring a reconsideration of the request or an award of just and equitable compensation, which is a similar regime to that applies for flexible working. If someone makes this request, you can't treat them less favourably or subject them to a detriment as a result. And if you dismiss them because they've done it, then that dismissal may well be automatically unfair with no qualifying service. So, what do you need to do? Well, you need to keep updated on this. So due to come in September, we are expecting some regulations to accompany it and a statutory code of practice, which will flesh out the process and what's required. You may need to consider introducing a policy for dealing with these requests. Do you want application forms like some employers use for flexible working? You certainly need to raise awareness because this is a new development. Your managers may not be aware that this is even a thing. Training on handling the processes, and just think about your agency workers as well. Are you going to be getting those types of requests in? What's the chance of that? And then just making sure that you are handling them in a compliant fashion. Right, moving away slightly from sort of working practices and looking at redundancy. So the current position in respect of redundancy protection is that first bullet point on the slide. So if you're at risk of redundancy and you're on maternity, adoption or shared parental leave, you have the automatic right to be offered any suitable alternative vacancy. Now, there's a lot of devil in the detail with that, but that's broadly the current position. That you essentially get this slightly enhanced protection if you are on those types of leave. Well, that is being maintained, but it is being extended. And we have this idea of an additional protected period. So that same protection will now apply from the point the employer is informed of pregnancy to either the start of statutory maternity leave, if they're entitled, or to 2 weeks after the end of pregnancy. For maternity, it's now going to be 18 months after the expected week of childbirth or the actual date of childbirth. Adoption, similar period after placement or entry into Great Britain, if it is a sort of a foreign adoption. And then shared parental leave, if you take 6 or more consecutive weeks of shared parental leave and have not taken maternity or adoption leave, then you get this protection for 18 months after the birth or placement. So same protection, extending it out. When does it apply for? Well, it depends upon which one of those types of the additional protected period you're looking at. But if it's the pregnancy one, then it's notifications on or after the 6th of April. Maternity adoption, those second 2 bullet points there, that's ending on or after the 6th of April. And then the shared parental leave, where your 6 weeks or more consecutive shared parental leave needs to start on or after the 6th of April 2024. A quick word on this is just to say be very careful. I think employers have got quite used to thinking about particularly maternity leave. Someone's on maternity leave, they're at risk of redundancy. They know that they need to be a little bit more careful. They're aware of this additional obligation. This is now obviously being expanded out. You need to check people don't have this protection as and when you are ever running any redundancy process or thinking about it. Right, next, we have a new form of leave, unpaid carers leave. So 6th of April, reoccurring date for lots of these things, 2024. If you have an employee who has a dependent with a long-term care need, they may take 1 week's unpaid leave to provide or arrange care in each rolling 12-month period. Key terms there: dependents, spouse, civil partner, child or parent, live in the same household, excluding lodgers, tenants, employees, etc. Or reasonably relying upon the employee to provide or arrange care. So that's your dependent. Do they have a long-term care need? Well, do they have an illness or injury that requires or is likely to require care for more than 3 months? Or are they disabled for the purposes of the Equality Act? Or do they require care for a reason connected with their old age? So quite broad definitions of those two things. If they do choose to take leave, they can take it as individual days or half days up to a 1-week block. The notice period to request it is either twice the length of the leave or 3 days, whichever is longer. There is no requirement for anything to be in writing or any evidence to be provided. And also, employers can't decline a request, and they can only postpone it if the business is going to be unduly disrupted. They allow leave of the same length within a month of the original request, and they give written notice within 7 days, giving reasons for the postponement and setting those alternative acceptable dates. If individuals do exercise this right, similar to as I was talking about earlier on, they are protected from detriment or less favourable treatment as a result, and from dismissal. Not a new form of leave, but a tweak to an existing one. Paternity leave changes. So currently, fathers or eligible partners can take either 1 or 2 consecutive weeks of paid paternity leave, and that is within the first 8 weeks following the birth or adoption. Now, we've got some changes to that. So it can now be taken as 2 1-week non-consecutive blocks, and it can be taken at any point in the first year after birth or adoption. There's a shorter notice period, and also an ability to vary those dates on 28 days notice. So more flexibility ultimately on when it can be taken. Essentially, it's going to apply to babies with an expected week of childbirth or expected week of placement for adoption cases on or after the 6th of April 2024. And again, similar to many of these things, update your policies, make sure there is awareness of these changes so you're not rejecting eligible requests. A couple of points I'll mention just in case they're relevant to people's businesses, relatively niche to an extent. We are due to have a new act as of the 1st of July of this year, trying to require that 100% of tips are passed on to the employee, or due a code of practice on that as well. And the domestic living exemption for national minimum wage is due to be removed from the 1st of April. So previously, if you live in a family home, you're treated as a member of the family, you're not charged food or accommodation, then you didn't used to have to get national minimum wage. So au pairs used to be the classic example of this. That domestic living exemption is going from the 1st of April. We've also got national living wage being extended to workers aged 21 and 22. Previously, you had to be 23 or over, so that's essentially the highest rate of national minimum wage. We've got increases to those rates from the 1st of April, and we also will have new rates for statutory pay, redundancy, etc., which at the time of recording this haven't been announced, but will come probably in March to be effective in April. Right. Bit of speculation, I guess, here really, but one thing that is certain is we are due a general election. So before the 28th of January 2025, we have to have a general election. At time of recording this, speculation is that that would either be May or mid-November 2024. What are the implications depending upon the outcome? Well, if it's a Conservative win, we broadly know their approach, obviously subject to whatever goes into any manifesto, and some of their initiatives are already progressing through Parliament. the key thing I wanted to focus on here was really what are Labour's proposals, and what I've summarised on this slide is a number of sort of things that they have indicated that they would be considering introducing, just so you're aware of potential changes to this sort of employment law landscape. So I will run through them quickly. The first one is a ban on 0 hours contracts, and also extending unfair dismissal protection to casual workers. The key thing I think with this is what sort of anti-avoidance measures might go hand in hand with it. So you could have a ban on 0 hours contracts, but would you also want to restrict those that guarantee of a small number of hours? So if you had a contract that said you're guaranteed 1 hour of work a week, you still have a huge amount of flexibility potentially under that contract. How will Labour regulate that type of risk? They want to ban, fire and rehire, which is the idea that employers dismiss employees and re-engage them as a means of changing their terms. They've suggested that they will also introduce reporting on disability and ethnicity pay gaps in a similar manner to there currently is for gender pay gap. Statutory sick pay potentially extended to the first day of absence. Big one is potential removal of 2-year qualifying period for unfair dismissal. If they did introduce that without any caveats or other elements to it, I think that would be a really material change for a lot of employers. Employers are quite used to the idea that they have up to 2 years, as it currently is, to decide really about ongoing employment and before they are committed to sort of full procedures. So that's one definitely to watch. Proposed removal of limits on unfair dismissal compensation, removing the cap on the compensatory award, giving people more time to issue claims, reform to trade union law, and sexual harassment. So I talked about the new duty earlier on in this session, and what they are suggesting is that they would introduce that liability for the actions of third parties, and that they would also change that reasonable steps requirement to all reasonable steps. Now, I've given you a few other areas just to watch on these slides. For sake of time, I won't go into in too much detail on them. We are getting these new strike minimum service levels being set. Some came through in December. Consultation about introducing them in the education sector, and also consultation about allowing employers to use agency workers when their regular employees are on strike. The government, we're expecting a response to their consultation and a code of practice in spring of this year on fire and rehire, essentially giving clarification as to when that is appropriate and how to do it. Right to work fines have been trebled. So figures are on the slide there. We've got a new data protection bill progressing through Parliament currently that will make some changes to the data protection regime once it's introduced. You may recall that the government is proposing a restriction on non-compete clauses, so post-termination restrictions, limiting them down to 3 months. That currently doesn't appear, famous last words, to be progressing particularly quickly. It is said that it will be brought forward when parliamentary time allows. It wasn't mentioned in the last King's speech, so it may not be a priority of the government prior to the next general election. We wait and see. And then we have some new rights for neonatal care, leave and pay, but that is unlikely to come in before April 2025. So one for next year's session rather than right now. So usual caveat with all of this, as you can guess, is a quick whistle-stop tour of some of the things that are due in this year. Some of it we're expecting new codes of practice, new regulations to go with it, so some of the detail isn't yet known. Please do take legal advice on your own scenario. I've mentioned on this slide here, we have a mock tribunal in conjunction with Devereux Chambers coming up on the 30th of April. That will be an online event, should be really good. We obviously have the sexual harassment prevention legal review offering, and we regularly record these free webinars, update various events as well. If you're interested in any of those things, or indeed have any questions on anything I've talked about today, then please do drop me a line or give me a ring on the details there. Thank you very much for joining me today. I hope you found it useful, and as I say, any questions, please do let me know. Thank you.